final case of the call is case number 167595, People versus Robinson. This is a mini oral argument on the application. For both sides have 15 minutes of argument. Mr. Gurwitz, if you would like to reserve time for rebuttal.
Yes,
okay, we just ask that you keep track of that. And you may begin when you're ready.
May it please the court, Harold Gurwitz, appearing on behalf of Todd Robinson. This court has analyzed questions concerning subject matter jurisdiction over decades, going back to the George case that has been cited, in decisions involving movement of cases between trial and appellate courts, where the charges were initially properly filed in both the district court and or the circuit court. Those cases include George, Washington, the People v. Washington, and Scott. In this case, the question of subject matter jurisdiction presented is straightforward: whether the circuit court, in the first instance, ever acquired subject matter jurisdiction, where the indictment that initiated the case was one issued by a judge acting pursuant to appointment by these two statutes, 767.3 and 767.4, and the case was filed in the circuit court without a preliminary examination and proper bindover. The answer to the question we submit is properly no. There was no subject matter jurisdiction. The circuit court should have granted Mr. Robinson's second motion under 6500. I welcome any questions at any time by the court on any of the issues that were addressed in the order granting our application for leave. Washington, George, and Scott, I would submit, are examples of cases where the circuit courts had jurisdiction to begin with. In Washington, the issue presented was whether there had been a proper...
Counselor, excuse me. So if I think about subject jurisdiction, matter jurisdiction, sort of like a box, right? And so Washington says at the point that there's a constitutional appeal, you are out of the box. The circuit court no longer has jurisdiction over your case. And so your case is about when it comes into the box, just
yes.
as a loose. And typically we would have a complaint, there would be a preliminary exam or a waiver, there would be a bind over, there would be an information. Which of those steps, in your view, puts it into the box, or combination of those steps, and which of those lacking is fatal to the ability to have subject matter jurisdiction in the circuit court?
Thank you. There are really three here. Initially and primarily, it is the lack of authority for the judge to act in the capacity as a prosecutor. At bottom, that issue really rests upon the problem presented by the state constitution separation of powers provision. The judge has no authority to act in that capacity. Second, the statute, 767.42, provides there must be a proper bindover in order for the circuit court to acquire jurisdiction. The same is provided by the court rule. So those are the bases on which we rest the argument that the court never acquired jurisdiction in the first place. This wasn't then an exercise of jurisdiction. This didn't involve in personam jurisdiction, as the responses argued, because there was never subject matter jurisdiction in the court at all. The only authority, according to this court in, for example, Fox versus Board of Regents, for the court to act was to dismiss. This is based upon, first of all, primarily, of course, the language of 767.3, which, as this court in Peeler explained, provides no authority to a judge to indict. It's based upon the history of the statute since 1917, which includes an amendment in 1949 by the legislature in an attempt to insert that authority, which was repealed about 3 years later with no subsequent action of any kind to provide any suggestion that there could be a semblance of authority to indict.
Counsel, why would prior case law that says defective information doesn't deprive the court of jurisdiction, or that if a defendant hasn't been arraigned, the circuit court still has jurisdiction? Why doesn't that apply?
I'm sorry, I don't think I understand exactly what the...
If a defendant hasn't been arraigned,
Yes.
I believe this court has found that that doesn't deprive the circuit court of jurisdiction.
Well, not just that the defendant hasn't been arraigned in the circuit court, but there is no basis on which the defendant appeared in circuit court. It's not a preliminary examination and bindover, according to the rule, are prerequisites. I think that word is used in Washington to a bindover. It didn't happen here at all. The court in Washington addressed what is meant by subject matter jurisdiction. It said it's the authority of the court to hear and determine a case. It, in Washington, though, said that that authority was divested after the filing of an appeal. What that is based upon, then, is the requirement that there must be some acquisition of jurisdiction in the first place. If there are no other specific questions about that point, I'd like to move on to discuss other issues that have been raised by the court and its order. But first, let me just say that in line with what I've just addressed, it is the Michigan Court of Appeals decision was wrong because it erred in holding that an indictment by a judge is just a procedural defect. In fact, it is a defect in the way in which the case came to the court without any authority.
Counselor, could you address Goki? I'm not exactly sure how it's pronounced, but that's used by both sides, and I think the prosecutor in this case suggests that the filing of the return, Goki tells us that that's a question of in personam jurisdiction, not subject matter jurisdiction. So could you address that?
Yes, I think that as perhaps the amicus brief may have said, that the opinion from this court in that case actually addressed both subject matter and in personam jurisdiction. It was a case of, as I refer to it, a vertical subject matter jurisdiction question, whether or not there was jurisdiction remaining in the circuit court after the filing of an appeal. And the answer is, as I've said, is that the court looked to whether there was still authority to hear and decide a case, and there wasn't. In personam jurisdiction, as the principles relating to exercise of jurisdiction, only apply if there is jurisdiction to begin with in the circuit court. And in this case, it just didn't exist. The order from this court also asked us to address the question of whether or not a 6500 motion is a proper way to raise this issue in the court, and it is in this circumstance for two reasons. The first one is, of course, addressed directly by this court in Washington, 508 Michigan at 131, in which it explains that the restrictions in those statutes providing for collateral applications for relief are not implicated here because they only limit a court's ability to consider a judgment of conviction and sentence. And this was not because there was no authority in the court from the beginning of its proceedings, in Mr. Robinson's case. There was no authority to address the issues. It explains that the case law establishes that the trial court's judgment of sentence rendered when the trial court lacked subject matter jurisdiction was void ab initio. Same principle articulated in Fox versus Board of Regents in the civil context. The same principle which was explained by this court in 1935 in Jackson City Bank versus Frederick. The second reason that there is a basis to ask for relief under the 6500 motion procedures is in 6508D3, which says that the bar for second and subsequent motions does not apply where in cases, or it does apply in cases other than subject matter, other than jurisdictional defects, which this is. An additional issue that has been raised concerns that of retroactivity. We've addressed that in two different issues. One is the question of whether or not the cases of Pohutsky and League of Women Voters in any way impacts the decision here. The initial consideration, of course, under those cases is that there must be a determination of whether or not there is a new rule of law. And we've said, for all the reasons I've discussed, that there is not a new rule of law in the circumstance.
Can you expand on that? Because I recognize this is a weird circumstance where everybody seems to agree that it didn't establish a new rule of law. But in Peeler, we expressly overruled a published Court of Appeals opinion. And we said that the power of a judge conducting an inquiry to issue an indictment was simply an unchallenged assumption until now. Why is that not sort of categorized as establishing a new rule?
Well, of course, Peeler concerned two issues. One was the question of whether or not a defendant who was in court pursuant to this procedure with a one-man grand jury had a right to a preliminary examination. The court explained that has always been the law. There's no question. There may have been some ambiguity, however, after the decision in Glass about whether or not that ruling concerning the citizens' grand jury applied to the so-called one-man grand jury procedure. But the Green case, of course, did not directly concern the authority of the judge to indict. It concerned whether or not the defendant in that case was able to raise a claim of ineffective assistance of counsel by his attorney, who did not have the ability to cross-examine witnesses during that proceeding and failed to raise the issue. So on that basis, that those principles don't come into play, I think. This clearly is an extant rule of law, both as to preliminary examinations and authority to indict. Just one further comment, and I see my time is running here to the point at which I ask to reserve time, but I just say that clearly this is an important issue to Mr. Robinson. In his case, he not only argues about the effect of the one-man grand jury statutes, but he also objected to the procedure in the circuit court by preliminary examination. I will reserve the remainder of my time for rebuttal. Thank you very much.
Thank you.
Good afternoon. I think it's afternoon. May it please the court, my name is Matt Way. I'm from the Jackson County Prosecutor's Office, arguing on behalf of the people of the state of Michigan. 90 years ago, in Jackson City Bank and Trust versus Frederick in this court made clear there's a difference between subject matter jurisdiction and the errors in the exercise of jurisdiction. This court explained that errors in the exercise of jurisdiction, no matter how grave, cannot be attacked collaterally. Defendants sought to do just that through his successive motion for relief from judgment. Then in 2021, this court issued an opinion in People v. Washington. And Washington discusses, among other things, the purposes behind the subject matter jurisdiction principle and rule. And that purpose is to ensure that two courts don't have jurisdiction over the same case at the same time. That's obviously not a concern in this case. And then finally, last year, in People v. Scott, which was issued just 3 days before our argument at the Court of Appeals in this case, was very helpful to the Court of Appeals. Because in Scott, this court made clear that non-constitutional issues remain outside the scope of jurisdictional concern. Scott's consistent with the United States Supreme Court precedent, like Custis, which clarifies that only the most unique and serious constitutional violations rise to the level of jurisdictional defects. Defendants asking this court to act in defiance of this court's long-term precedent as well as United States Supreme Court precedent. The Court of Appeals correctly applied that precedent to this case, and this court should either deny defendant's application or affirm the Court of Appeals. I want to talk a little bit about the implications of holding otherwise. Not only would we have to be retrying, I don't know how many cases, I've tried to figure out how many cases, but we would be retrying cases not based on deprivation of a right to present a defense or serious evidentiary issues. We would be running these same trials over and over again, same exact evidence.
Can I ask you, to that question, I know that it's hard to, can't ask for a exact quantity, but I think, at least speaking for myself, I think at the time of Peeler, like it was presented as a fairly rare procedure, and yet, you're here today. There are others here, I think subsequent to that, hearing that in fact this sort of procedure is perhaps more common. Are we talking there's some, but it's insignificant? I mean, I think that's relevant to like what are the impact of what we say? Is it in fact going on?
Sure. So I know in Jackson, I've been with the office almost 13 years. We've done 3 or 4 of these, so a handful of them. My best guess, I tried to work with the clerk to get an exact number, but it's hard to figure this out. There's probably between 10 and 15 is just kind of an estimate.
In your county?
In just my county. I know Wayne County used this. I put out a question to appellate attorneys in the state. Wayne County indicated they have no less than 200 of these, which are primarily non-fatal shootings, is my best understanding of it. And the impact of the other, I think, thing that we need to think about in terms of the impact is not this would, under defendant's logic, this would apply not just to convictions, but to acquittals. If we're talking about this case, that this case was just null and void because there was no subject matter jurisdiction, defendants who have been acquitted, who have long since moved on with their lives, could turn around and face serious charges, once again, be placed in jeopardy, depending on what kind of prosecutor they run into. So I think that's a very serious implication of this decision. Justice Thomas, I did want to address your question.
Yeah, so I've got the box, right?
Yes.
So there's the complaint, there's the preliminary exam, which would typically happen in district court, so maybe there's 2 courts at the same time, then it's typically bound over to circuit court. There's an information filed. So you agree, even though the circuit court's a court of general jurisdiction, you can't just walk in and 10 minutes later try someone. There's got to be some way to get into the box. What is it?
So, there has to be some sort of, and this is from In re Ferrante, which I think we say it in our brief. I think this is the rule that's been laid out by this court. There has to be Ferrante calls it a petition, so there has to be some sort of charging document fairly alleging the circumstances upon which the court has general jurisdiction. In this particular case, that would be, it could be a complaint, it could be an information, which alleges that a murder, or that a felony, took place. In this case, 3 days after the order granting an indictment and warrant was filed, or was entered by the court, an information was filed by the prosecutor alleging defendant had committed open murder. Open murder is clearly a felony in the state of Michigan. At that point, the circuit court clearly had subject matter jurisdiction. I think Ferrante's real clear on that. And I would also point out to Madam Chief Justice, you wrote, and it's not a majority opinion, but you wrote a concurrence in People v. Oslin last term, talking about, and Justice Welch, I think, signed onto that, saying this was the juvenile direct waiver issue.
Remember.
Once the complaint had to allege an actual the juvenile violation, I forget the exact term right at the moment, but once that happens, there's subject matter jurisdiction, and I think that's consistent with Ferrante, and so I think once that information was filed in this case, the circuit court had subject matter jurisdiction. Certainly we can debate there were certainly errors leading up to that point. We don't contest that. But the circuit court clearly had subject matter jurisdiction once the information was filed alleging defendant committed a felony in the state of Michigan.
How do you address Evans? I think that's the case that is used by the defense. So how would you address Evans or distinguish
Evans, I would love to address Evans, because I think Evans is one of these cases which the court warns about in Washington, which doesn't precisely use the term jurisdiction, doesn't analyze it super closely. One of the things to note about Evans is it never uses the term subject matter jurisdiction. There is a case that cites Evans from this court that does do that, and I did not cite it in my brief, but I found it, particularly looking to see and relies on it. It's a 1986 case from this court, People v. Johnson, and the site is 427 Mich 98. This is the case that talks about the degree of murder doesn't need to be proven at a preliminary examination or in information. And defendant talked about prerequisites. Well, in Johnson, this court said on pages 105 and 106, talks about that bind over is a statutory requisite to the filing of an information. Then on page 106, this court said that, quote, this statute is a limitation on the prosecution, not on the general jurisdiction of the circuit court. Following that quote, there's a footnote 7, which cites a number of constitutional statutory provisions, case law, that we cite that talks consistently about the circuit court being a court of general jurisdiction to be able to track felonies. And then there's a final quote that I wanted to make sure to talk about, which is page 110. This court said, the trial court had subject matter jurisdiction to adjudicate first and second-degree murder cases by virtue of the power conferred by the Constitution and statutes. It had personal jurisdiction over Mr. Johnson upon the filing of the return by the magistrate as provided by statute. So that opinion could not be more clear that the bind-over issue is one of personal jurisdiction. And that is, I think, pretty much the exact same language that you see in Goki. I pronounce it the same way. I think it's Goki. I did want to just address retroactivity real briefly, because I think, going over my briefing, I wish the order of it was a little more clear. We're here on a subsequent motion for relief from judgment, or successive, excuse me. So I don't think the issue in this case is particularly whether it's retroactive or prospective generally, because the defendant, to meet the procedural bar, taking jurisdiction out of this, the defendant has to show a retroactive change in the law, not just a retroactive case. And while there's maybe, the court can decide whether it's retroactive, but this Peeler certainly didn't represent a change in the law, and I think the opinion's fairly clear on that. I understand it did overturn a case which I don't think is directly on point to Peeler, or no, I shouldn't say it, but it deals with a separate part of Peeler than what we're here for here today. Lastly, I'd just like to address the separation of powers issue that defendant kind of briefly mentions, and CDAM spends a lot of time on it. Because there's simply no separation of powers issue here. And I think I want to draw a couple examples, or a couple analogies that I think are instructive. If, let's say Mr. Robinson had a preliminary exam, or anyone has a preliminary examination, the state's precedent is very clear that at a preliminary examination, the magistrate or judge can add charges. They can raise charges. They're perfectly entitled to do that. Under CDAM and defendant's logic, that would be a separation of powers. There's a Court of Appeals case, People v. Gonzalez, 214 Mishap 513. That was a 1995 case. And that's one of the first. Around that time is the first time that the Court of Appeals kind of grappled with this. And in Gonzalez, the Court of Appeals specifically held that there is no separation of powers violation. There's then a footnote talking about how they're not addressing whether there would be a separation of powers issue if a magistrate or judge did this over the objection of the prosecutor. And I think that's the key. The judge is kind of consenting or just signing off on the prosecutor's wishes. Every case I'm aware of that's directly on point on the separation of powers in terms of a charging decision, the prosecutor is the appellant. And I think that's for a very good reason. The prosecutor is kind of the aggrieved party. when a judge acts in violation of separation of powers. The other example I would draw for this court is the signing of an ollie, or just the dismissal of a case. When a case gets dismissed, a prosecutor can't just take an order, sign an order, take it to the clerk and say, hey, this case is dismissed. Prosecutor files a motion for an ollie pros, gives that to the judge reviews it. If the judge is okay with it, the judge signs it, and the judge dismisses the case. The judge is, again, kind of looking at what the prosecutor is seeking to do, approving of it under the law, and the judge is acting. Now, if under CDM and defendant's logic, the judge would not be allowed to do that because the judge is counteracting the prosecutor's original charging decision, even though the prosecutor is the one who's asking for this to happen. In this case, the prosecutor filed a petition for the one-person grand jury. The judge agreed. Again, maybe the correct procedure wasn't followed, but we would submit that that's a procedural error. The prosecutor went forward with the case because it wished to try the defendant on open murder. If the judge had acted in violation of the prosecutor's wishes, the prosecutor simply could have dismissed the case. And I think the statute also provides some important safeguards that the legislature put in place. The judge overseeing the investigative portion cannot preside over a motion on the indictment or the information or at a trial. So it's our position that there's just clearly not a separation of powers in this case. Does the court have any other questions? All right, thank you very much.
Thank you.
The information provided today for the first time by the Jackson County Prosecutor's Office that there are a certain number of cases that would be affected by this hasn't been presented previously in either their response brief or in Pam's brief as well, representing prosecutors all over the state of Michigan. In spite of what they now claim to be concerned, they never raised the issue before. This issue, however, is really completely different in this circumstance because this is not like the considerations by the court in the Barnes case, which they did cite, where there was a question of retroactivity and concern about the effect on the administration of justice. This is one where the plain concern is whether or not the court had authority in the first instance to begin the case. The clear law of the state is that a defendant always has the right to object to jurisdiction. They want to say that because it might have an effect on the administration of justice, that there should be some exception to that rule. And I think that would run counter to a long line of case law to the contrary. The basic difference between this and the cases that the prosecutor has been arguing about relating to in personam and exercise of jurisdiction is that there was no jurisdiction here in the first place. This is not a question of whether or not the prosecutor's office may have filed an information and may have included a charge that was beyond the scope of what happened. It is really a question of whether or not a judge can act as a prosecutor. And that does present a separation of powers question. The court in Peeler said we don't need to answer that because we based our decision on statutory interpretation. But any other result, I think, here would require the court to address the constitutional issue in this circumstance. I'd be happy to answer any other question if there is any.
Thank you.
Thank you all very much.
The case will be submitted, and that concludes our October call. Thank you.